So cancellation of removal, as I said, is a form of immigration relief available to certain individuals to be placed in removal proceedings. Today I'm going to focus on cancellation of removal for certain lawful permanent residents. There's also cancellation of removal for persons who are not, they're not permanent residents, have been in the country for 10 years, and there's a whole other area there. We're just dealing today only with cancellation of removal for permanent residents. You'll see that I just had a handout there. I'll get to that. So this is just some practical tips. And I think that Sophie went through the whole referral and preparation part, but in terms of how they get to VLP. So we talked about lawful permanent residents. You'll see LPR. Immigration loves to use acronyms. So LPR is one of those. And so like I said, if any person not a citizen in the U.S. who is residing in the U.S. under legally recognized and lawfully recorded permanent resident as an immigrant is accorded the privilege of residing and working permanently in the U.S. So a person can come here as a permanent resident having been filed for by someone else, or they can acquire their permanent resident afterwards as adjustment of status through marriage, work. There's different various ways. So the persons that we're dealing with here when they do cancellation of removal, and just to note, this application is only done in court. It can't be done anywhere else. These people have either entered as permanent residents or they acquired their permanent residence after entering. Okay, so here how they actually get into the hands of the court. They were permanent residents. They may be placed into immigration proceedings and may be deported due to certain criminal convictions that make them inadmissible or deportable, as Sophie had mentioned before. So these people are in immigration proceedings. The client will be a lawful permanent resident with one or more criminal violations or convictions which make him vulnerable to deportation. As Sophie's mentioned, if your client is detained, VLP is going to first meet with them via the legal orientation program, which is held weekly at the Buffalo Federal Detention Facility. This is not actually Buffalo, but in Batavia. If your client is not detained, VLP would have met with him at the detention facility before he posted bond or via intake process. So this is where they determine who is eligible. This is a statutory, and as you see, it's under Section 240 of the INA. This is how they determine, the law determines if a person's actually eligible. So there's two parts to the cancellation of removal process. It's statutory eligibility has to be determined first, and then we're going to get to the discretionary portion after. So, and this determination is already made by VLP, but just in general, to be eligible for cancellation of removal for permanent residents has to be an LPR for not less than 5 years and has resided in the U.S. for not less than 7 years in any status. So the person technically does not necessarily have to have entered as a permanent resident. They just have to be living here for at least the 7 years and not be convicted of an aggravated felony. Bob said I'm going to go through all that in detail. I'm not. I'm going to tell you that there's a list. I think that handout there gives you a list of, there's a lot of them. In INA Section 843, there's a long list of things which make a person an aggravated felony. The obvious ones are murder, rape, and such as that, but then you have some that are, theft offenses, where the reason why it's an aggravated felony is because the sentence is more than a year. It's not necessarily because it's theft or anything. It's because it's based on the fact that it's more than 1 year. Or you have drug offenses, which don't have anything to do with the length of the sentence, but have to do with whether it's a sale. So drug possession is not an aggravated felony, but drug trafficking. And just to note, drug trafficking does not necessarily mean a person in a drug cartel. It could be sale of a marijuana joint, but that's a whole. But there's litigation on that as well. We're not going to get into that. But just in general, if you want to know, there's a handout there that gives you a list of things. If a person has that aggravated felony, they're not eligible for cancellation of removal. And as been noted, if you're taking on the case, you're not going to have to deal with whether or not they're already eligible. They're going to give it to you as a person who's eligible. Me now, I will get cases, and I have a few right now, where I'm battling to argue that the person has not been convicted of an aggravated felony, so they can be qualified. But you won't have to deal with that part of it.
Excuse me.
Yeah, go ahead.
It's convicted?
Pardon?
It's convicted?
Convicted. Yes. So, I wanted to make a note, though, on this residing in the U.S. for not less than 7 years in any status, because there's this thing called what they so-called stop time rule in cancellation of removal. It's also in the statute. You're not going to have to deal with this, but just so you know, the time can be stopped if at any time before the 7-year period they either get convicted of a crime that's mentioned in the statute, or they get issued a notice to appear. So you might have a person who's a permanent resident for the 5 years, but they got a conviction after 6 years. And so that person technically would not be eligible for cancellation of removal because they didn't meet the 7 years. And here's the thing, that person may have been picked up 10 years later, but if the conviction actually occurred on the 6th year, but immigration decided to take 10 years to find them, they still would not be eligible for cancellation because the stop time rule is in effect. Like, you wouldn't have to deal with that, but I just wanted to put that in there. Okay, so the charges. So the notice to appear, I believe you have a copy of that, that's where you're going to know, the NTA is going to say, that's another acronym. NTA is going to say what the person has been charged with. And so you'll have the top part there where it'll usually say you're a citizen, or you're not a citizen or national of the U.S., you're a native of this place, you were admitted at this place, and it'll usually say you were admitted. If they're a permanent resident, it'll say you were admitted on this date as a permanent resident under this category. Or if they were admitted as a visitor, per se. You were admitted as a visitor on this date, but on this date, you adjusted your status to that of a green card holder. And it will be up there. And then one of the last charges will be that criminal conviction that gets them into the situation. And the second part of the NTA is actually going to tell you what section of the law the person is removable for. And usually, if they're eligible for cancellation, we'll concede that they're removable for being convicted, but as relief from removal, we're going to be applying for cancellation of removal. And so this is the form. Everything in immigration is a form. They haven't reached anywhere near dealing with environmental issues. It's very paper intensive. And this is one of those applications that is extremely paper intensive. So the form is the EOIR 42A, and that's where you can find it on there, www.justice.gov, EOIR forms. You can just type in Google, go online, it'll be on there. But the actual, the detainees will be given a copy, and they're told to start gathering the information, because this type of application is information intensive. After the statutory part has been dealt with, now we get to the discretionary part. And it's going to be a balancing, and we'll go through that. It's a balancing test. But the first part is just biographical information. If you notice, they have to know, you get their date of birth and all that kind of stuff, where they've lived. But you have to list for the last 7 years where they've lived. And it's hard for some clients to even remember where they've lived for the last couple of years. They might be all over the place. And I personally, they just say the last 7 years, I like to sometimes ask them, especially if they've been here a long time, just for effect, like to show like all of the addresses where they've lived. So I usually say, okay, you need to start figuring, I don't know where I live. I don't just figure it out. You need to go, if you need to go back in history, even if you don't know the actual address, sometimes, okay, it was this street in this state. Try to know. And funny enough, depending on which chief counsel you get, knowing how long you lived at a certain place, if there's any gaps, they're going to notice. Some chief counsel doesn't care. But others, oh, well, you said you lived here from this time till that time, but why is on your application, you said you lived here from this time, but there's a gap of 5 years. What were you doing for that time period? You know, they actually want to know. You'd be surprised, but they actually want to know what you were doing. And then the second part is just telling you have to list where you entered into the country. Another part of the application, you gotta actually list the date when the person entered into the country, when they got their green card, if it was actually extended or not, if it's still valid. And it's, even if a person may actually have an expired green card, they're still actually a green card holder until an immigration judge says so. So whether or not it's actually expired doesn't necessarily mean that they've lost their permanent residence. They want to know if you've been married, and if you're married, want all the information about your spouse. you know, where your spouse is working right now, how much they're making, if they got their permanent or citizenship through permanent residence to naturalization, when they came into the country. This is where they pretty much want to know everything about you. They want to know all your children that are here, where you've been employed, and the difference with the employment section is that they actually, with the addresses, they want to know the last 7 years. On the employment, they want to know everywhere you have worked since you came into the United States. And if there are any gaps of unemployment or anything, you actually have to state that on there. So when you see the application, you'll notice the application on the first page only asks for the last 7 years of your addresses, but for the employment, it actually asks for all of your employment since arrival into the United States. There's never enough space on the form to put that, so you'll have to do an addendum. If you have clients, like I do sometimes, who've been in the country for 45 years, you know, we're going all the way back to what were you doing in 1980? I just had a client like that where he has to, and I have, you know, W-2s from 1987 that I'm putting in. You'd be surprised what people can gather, but they actually like to see that. So, but that is actually one part, the financial section, where they want to know everywhere you've worked. If there was any unemployment, anything like that, then they also want to know if you paid taxes. Taxes is huge.
Can I interrupt you for just a moment, because you made a really good point that has me thinking. Now, we're all clear that this is the relief that's applied for when we have a permanent resident who's been convicted of a crime. So there's already a criminal conviction in their lives. And Shauna brings up a really good point that your opposing counsel may go through this form with a fine-tooth comb, and if there's gaps in addresses or employment, ask a lot of questions. And what they're looking for, believe it or not, is if you weren't working for 5 years because you didn't put it down, what were you doing? Maybe you were dealing drugs to survive. Or maybe they're looking for suspicious activity. These are people with criminal convictions. They have to prove rehabilitation, remorse. Shauna will go into that. But this is why the government likes to poke holes. So make sure that when you're completing these forms, you do not do it lightly, that you have explanations. If your client was in a homeless shelter, the homeless shelter should be listed on that. They don't know the address, homeless shelter, New York, for X period of time. But if not, the government will go after these things because they want to know how people support themselves. And that's why the work history is so long, because if you are not working, you're either getting public assistance, which you may or may not have been eligible for legally, or you are doing something illicit. And there's already that doubt because of the criminal activity of our clients in this situation.
And speaking of the public assistance, we actually asked you that question on the form as well, whether or not you have obtained public assistance, or if any members of your family have obtained public assistance, and when and why and for what period and what type of public assistance. They want to know that. And then one of the main, this is part 7, this is where you actually have to put your criminal history. And the thing I should note is that they ask you whether you have been arrested, summoned, convicted, fined, imprisoned, placed in probation. So it's not necessarily always just the convictions that you place on the application form. Because some people think, okay, well, I was only convicted of this, but how many times were you arrested? What happened? Like, if a person's been arrested 10 times, you list all the arrests and what happened with those arrests, even if they were minor, because there has to be an explanation, because because this is very common. Clients will say, well, oh, I was only convicted of this. Okay, how many times were you actually arrested? It was just this. No, I need to know how many times you were actually arrested and when and what, because if I don't bring it up, government counsel is definitely going to take out the rap sheet, and they're going to say, okay, on this date, you were arrested for this. So what happened there? And then the next question is, why, when your counsel was asking you about your convictions or arrests, why did you tell them that you only had this? You need to list everything, even if it wasn't. Yes, it's good to say arrested, case dismissed, arrested, probation, arrested, this, so that there's not because they might think, okay, I only received one conviction, or they might say, okay, I was convicted of this. Okay, anything? Oh, nothing else. Just this, just that. And it turns out that they have all these, because they think that their misdemeanors aren't convictions. They'll just think, okay, well, it's just the felonies that you care about. No, we care about every possible thing. So that's key, because although there might only be one conviction listed on the notice to appear, when you're dealing with this type of application, the one conviction that makes them removable is not the only conviction or arrest that can be considered for, because this is a discretionary relief. So the judge can look at everything, not just the conviction that makes them removable. Okay. So let's get to the meat of the matter when it comes to cancellation of removal. In addition to satisfying the 3 statutory eligibility requirements, which we've gotten at, cancellation of removal, they must establish that the person warrants, this is key, such relief as a matter of discretion. And the general standards developed for that is found in the case law there. And when we say warrants, the term, the person who decides is the judge. That's the who decides whether or not he warrants it. And so it depends on what the judge feels is what they consider to be important on that day. And it's always a balancing test. This is the balancing. So the more negative, the more positive that you have to show. The court should consider the record as a whole and balance the adverse factors evidencing the alien's undesirability as a permanent resident with the social and humane considerations presented in his behalf to determine whether a grant of relief would be in the best interest of this country. That's quoted from Matter of CVT, which is the main
And it's
case.
in your material.
Yeah.
The copy of CVT is in your material.
The more, like I said, the more negative factors that exist requires more positive equities to outweigh the negative. Judges weigh the evidence in context. Example, age of the criminal history, consistency in employment, active parenting. This is key, not just having children, but actually parenting them. A person might say, okay, I have 7 children. Okay, when was the last time you spoke to these kids? When was the last time you were there for these children? Do you pay child support? If you have to pay child support, why? What happened? Because they could have children, but they don't know where they are. And so if they have children, but they don't know where they are, I'm not going to place that much importance on these children because they're not, because it's actually going to turn out to be a negative for them that they have all these children, but they don't actually take care of the children. So that's key. All right. So we're going to go through some helpful documents. What I gave to you here is kind of an outline of how I actually prepare my applications. Preparation is the key to this type of a case. You have to talk. You're going to be talking to your clients. You're going to be talking to mothers, brothers, different people. It's because after you pass the statutory portion, this is about document gathering. So you're going to have to encourage your clients to try to remember all the people that they've worked with. Try to remember where they've lived. They have to be helpful. Sometimes they don't want to be, but they need to be. They have to be helpful in here. But you, as a volunteer attorney, have to be prepared to be running down some people, to be talking to people, to try to encourage. Could you write us a letter, please? Could you, because I have to do that sometimes, where you may have a wife who's maybe being a little difficult, doesn't necessarily understand the significance here, or there may have been an issue in the home prior to them coming into the situation, but they have 5 kids who she's holding all of their birth certificates, and you need their birth certificates, and he was a good father, they just had a situation at home, and so, you become all types of different people. As lawyers, we know that we're not just lawyers, we vary into some other areas as well. But this, I have 2 examples here of, tables of contents are excellent. This is just my way, but there's any way you'd like to do it. But this is a general header of how the court, and these are 2 of my more recent cases. The first one here, this guy had actually only been in the country for about 12 years, but he actually did a lot in his 12-year period. If you see, you organize it, the forms, you have evidence of remorse. I love to get my clients to write their own personal statements so that they can explain what happened, how they ended up in the situation that they're in. Then letters of support from family members, letters of support from friends, evidence of family ties. If they own a business, if they've worked, tax returns are huge. If they have tax returns for every year that they've been here, I do not have a problem with showing a copy of every single year of tax returns. So, like, I just had a client, he's been here since 1980. So we have about 35 years of tax returns and W-2s, and it's in the package, and they will get that. Because you may have a situation where you can go to trial on all of them, but there might be cases where the government might be willing to just concede and say, okay, we agree that he should be granted this, and we don't have to actually go through an entire trial based on what you actually have provided. And that's the second package I have. That's the March 20th, 2015. I think I submitted documents about 3 different times. I didn't actually have to do a trial on that case. It was based on just the documents alone. The government agreed to say, okay, we're not going to, we concede. He deserves he deserves this relief. The government agreed as well. So, but you're still facing removal, and you're still facing a situation where you are in front of a judge, and it is that one judge who determines whether or not you've met the balancing test here. And so some of the other documents that demonstrate family ties. So you're going to have your birth certificates for your children. You're going to have the passports and citizenship certificates of all the family members that you have here. That's another part of the actual application. It asks you to list all of your people that are here, your kids, your wife, husband, aunts, uncles, everybody. So if they have a ton, I'll give them a list of 35 people or 50 people. Where are they? They're everywhere, all across the entire country, just to show that this person needs to stay here. Employment history of paying taxes, property. If they own a house, include a copy of the deed. If they have paid, like I said, paying taxes, W-2s, those things, submit all of it. If you have it, submit it. If they can find it, this is where you will learn how to request. If they don't have it, get the form from the IRS. Request all of them. I've had to do that. They have access sometimes in the detention facility to just call directly, and they will have them sent to them. Or I'll get them to complete the form, sign the form, to have the document sent to me. And they will send it. You just have to get them to do that. And a resume. If they've had a long employment history, sometimes it's just good to just have them a copy of their resume. But like I said, on the application form, they require a listing of every job. Then they've volunteered anywhere, letters from anywhere, the churches they've gone to, if they work for the Red Cross, all of that. You can get those letters. Education, if they've wherever they've gone to school, if they have degrees, if they have anything like that. Copies.
Even earned in prison,
Yes.
GDs earned in prison, and other programs that they've participated in prison.
Exactly. They were in prison for a while, showing that even while they were there, they were trying to actually, goes to the whole rehabilitation. So although they were inside, they were actually trying to do something to better themselves. So if they have their certificates, get them all. And if we have to make requests to the prison, we do that. Yes, rehabilitation, accepting responsibility. This is huge. The court is not interested in you having a discussion about whether or not I didn't do it. We're past that. And honestly, there might be a situation where there is a legitimate argument to be made, but sometimes I have to be frank with some of my clients, like, okay, I understand you felt you didn't do that, but it's 5 years now. If you had an issue with it, that should have been dealt with here. Now I'm dealing, the immigration judge doesn't have the jurisdiction to retry the criminal case. They are faced with a conviction in front of them. They can't go behind the conviction. So you need to be prepared, the client has to be prepared to take responsibility. Sometimes in the way that I ask the question, if it really is a question as to whether or not he did it but he took the plea, I'll ask, okay, if you didn't do it, why did you take the plea? We'll go through that. And then it's left up in the air. Nobody's going to be making a decision on whether or not they're guilty or not. And there is a guilty plea, but depending on the circumstances, I'll put it out there, because the conviction, they get to look at, they can't retry the case, but they are able to look at the facts and circumstances of the conviction. So if they look at the facts and circumstances, that's up to the judge to determine. So as we're explaining, because the government counsel is going to want to go down the path of, okay, what were you doing at 6:30? Why did you get arrested or whatever? So before they get there and try to twist it in one way, I will try to present it in another way. And so, okay, this is what occurred. And in that, there will be an accepting of responsibility. I put it out there from the front end so that the government does not get an opportunity to twist it in another way. If they have a conviction, we deal with it up front, we accept the responsibility, and we move on. If the person has, okay, since they have, if it's been 10 years, okay, what have you been doing since you got convicted in 2006? Okay, what did you do to change your life? What makes, and then the question is, okay, how is this court going to be assured that if you get this second chance now, that you're not going to turn around and go back? Because sometimes the question is, oh, it was my friends, it was my, okay, so what if you get out today? Are you going to go back to deal with those friends? It's just hitting it on the front end so that there's an opportunity for the court to do the proper balancing test.
And I really respect Shauna's tactic. If your client insists he was innocent and he was wrongly convicted, this idea of, well, why did you take the plea? It's dangerous, though.
It is dangerous.
I wouldn't go out and do it until I knew what I was doing. Because it can backfire big time. The government lawyer is going to say, you don't accept responsibility. You're still trying to deny your wrongdoing. I would do it, and I have done it, like Shauna, if my guy has one darn conviction in his life. He got it when he was 35. It's made no sense that a law-abiding 35-year-old, 40-year-old suddenly went out and broke the law. And there's nothing else. But if the guy has a rap sheet a mile long, you gotta read him the Riot Act. You gotta sit down. Nobody's gonna believe that on 10 convictions you never did it. At a minimum, get him to admit that, you make bad choices in life. Did you know the guy you were hanging with that you called your best friend was a drug dealer? Well, then why are you hanging out with him? And let them, talk and accept responsibility for those bad choices. It's really very important in immigration court. Like Shauna said, the judges accept that the criminal justice system did its job fairly, and that if there is a conviction, that conviction was properly entered. And that's the end of the story in immigration court.
Remember that the immigration judges will consider many factors in deciding whether the applicant deserves cancellation of removal, including how long they've lived here, family or community ties, community service, membership in clubs, work history, filing. All of these things is all taken together. So you the way that I like to organize my applications in kind of that order. I look through the case matter of CBT, and I'll kind of go through and see how many of the factors they hit. How many of them are they able to do? I mean, I don't do this anymore when I had a little bit more time. I used to prepare a memo to go along with it. Sometimes it works as I provided a copy of a legal memo that I do sometimes. It's just legal argument, so it's not going to be considered evidence. But sometimes, if you're able to, if you do that, I just kind of do a basic outline of the law and then how my client fits into that, and then go through each of the actual categories that they meet. It's the same kind of order as the notice of the actual, table of contents that I've provided, but I kind of go through it, especially if it's a really good case. Because then what I'll do is I'll put all the positive factors out front, and then I'll just put a little piece of the middle of the part where the negative factors we acknowledge, especially if you have a case where it's a client with one conviction, and they have all these other positive equities in front of them, then it's the balancing. Then you're left with a situation where the judge has no choice. You want to make it so that the judge feels like he has no choice but to grant your application. You want to make it so that the government wants to concede, or even if we do have to go through the entire trial, that at the end of it, they're just waiving appeal and say, okay, we accept that this person should be granted it. But you are going to have those cases where it's a tight case. You don't know which way it's going to go, because the person might have 2 or 3 convictions, and they might not necessarily have as many of the positive equities as you want. And those cases are there's no guarantee on any of the cases, but on those tighter cases, it really boils down to what happens on that day in court. How well does your client go off to the client? How many supporting persons do they have? Family members are huge. If you can get the wife in, even if the child is old enough to give testimony, get them on that stand. Sometimes, tears work. Sometimes, if somebody's going to cry, and it probably will, because it's the idea that 45 years now later you're trying to deport this person. It's very emotional. It's a very emotional experience. The whole immigration process can be. But on this day, if you can get, and it's hard sometimes when they're detained, especially because the family members are so far in certain places and they might not necessarily have the funds to bring them up there. But if it is possible to get a family member to come, then you do that. I mean, I've had cases where it just was impossible for the wife to come, but as Bob said, the court has an ability to allow for video teleconference. So I was able to get the wife to appear by video from Texas to be able, and the court, the Texas immigration court allowed for, we made the arrangement so she could appear because she was the key to the case. So, we wanted, the judge wanted to hear from her, and so she was able to appear.
Let me just reset with that if I can.
Go ahead.
Because the only times I've ever had real trouble in cancellation cases is where nobody showed up.
Mm-hmm.
I had guys who lived here for 30 years. Nobody could come to the hearing. And I've had judges tell me afterwards, you mean nobody could come? You could get no one? The only time, and Sean is right about one of the things as well, is that tears always work. If they're real. If they're real, they will always work. I have never been involved in a case that wasn't successful where somebody cried. Usually mom, usually my guys are a little younger sometimes, but a girlfriend or a mom or a 17-year-old who comes in to testify. The judges don't like you to bring anybody who's under about 14, really. But if you have anybody else who can come in and testify, stepchildren have been wonderful witnesses. But I want to just stress the importance of having people come in and say, this person means a lot to me, I need to have them stay for me. It's not about that, it's about the balancing test.
Yeah.
But trust me, if there's U.S. citizens and others who come in and say very positive things, that goes a long, long way.
As long as they're realistic,
Yeah.
though. I'm gonna, to the caveat about moms, holy cow, how many moms say, my son is such a nice boy.
Yeah.
Oh my gosh, no, he never did what they say he did. Your Honor, this is the rap sheet. Mom is living on the moon. Because if the judge thinks that the family's not going to be there to whip them into shape when they get out, they're not going to grant. They want a family who says, yeah, he's got a drug problem. Yeah, we're going to do this and that and the other thing if he starts touching those drugs again, and he's going to get in trouble. We don't want the mom who's just crying and saying, no, he's a good boy. You know, he's a real good boy, and you're looking at really awful crimes.
It all boils down to the balancing. At the end of the day, it's a balancing. So you have to determine, okay, when I'm even, because it also comes down to preparation. You need to prepare your client, and you need to prepare the supporting evidence. You can't go in there not knowing what your client's going to say. Sometimes they go up there and they just like, oh, well, there goes that. But, but then, it's the supporting evidence that you have. Submitting, organization is very important for these type of applications. I found that judges, they don't want to have to be flipping through and trying to figure out where the documents are. Label everything properly, follow the court rules as to how for submissions. The judges love it when they can just, okay, this is a tab here, you put your table of contents. If they don't have to go very far to see the actual letter that you're referring to, it's great, because then they don't have to do much. It's all presented there for you. Prepare your client, prepare the witnesses as well for the direct testimony, because they've probably never been in a court before in their life, and they just need to, and it's, immigration court is a little different, but just prepare them for what, is expected to be said. I think in these type of cases, which I've done a number of them, you don't always win them. The VLP is going to vet it for you, so you're probably going to get a case that's probably on its way to winning anyway, but you just really have to, it just boils down to the balancing test. Try to do it, try to get as much on the positive side. The more negatives that your client has, the more positives that you have to get. And you have to be realistic with your client. If you have a client that has been here, yes, he's been here for 35 years, and I think one key here is that even on the employment, the length of the employment is also important. So whether or not the person has had 50 jobs, that's a problem if you've been here for whatever. Why are you just jumping from job to job to job? I've had a judge, okay, yes, you've had all these jobs, but why are you only staying at the job for 8 months, 9 months, 6 months? What's going on? And then the issue is probably because he has a drinking problem, and that's the reason why he can't stay on the job for that long. So it's better that, yes, you have jobs, but that you stay at them for 10 years. You've been an employee for this long. So everything is balancing. So yes, you might have a long job history, but then there's a problem if the job history is a short job history at every time. So it's a lot of document gathering, a lot of cajoling different people and families, huge. And not just necessarily immediate. If you have community members who are willing to come, like judges like to see, okay, you have yes, your family's here, but you have somebody that's actually not related to you, that's willing to travel and come here. I had a case where the guy, he was Dominican or something, been here for like 50 years, and he was not necessarily a person that you think, okay, he had a couple convictions here and there, and but the reason why he was able to, we were able to win was because of the fact that we got his stepfather came in and was willing to testify on his behalf. We had people who weren't necessarily his immediate family, but other persons came in and willing to testify on his behalf, and the government actually had opposed that one that day, but the judge granted it. And when the judge granted it, the government waived their appeal. But, it all, it's just a balancing, like the individual hearing, which is like a general trial, where I talked about direct examination of your client, examination of witnesses, talk about the rehabilitation, there's cross-examination. And the cross, it all depends on which trial attorney you have. It really depends on the trial attorney, as well as also the actual package. If you have a package that is strong and such, and you've gone through everything on direct, you might get, by the time it gets to cross, the government might not have much questions to ask. But if it's a situation where it's close, and they're probably just going to be resting on the criminal issues, they might not even, they know all these kids and everything, but if he has 4 or 5 convictions, they're going to be resting there. So you need to prepare your client for that. Like you said, individual hearings can go from one day, we had 9 in the morning or 1 in the afternoon. We're trying to get it done in a day, but sometimes it might go. But cancellation cases I haven't had a cancellation case go longer than the time span that is given to me. And of course, the ones that they grant before I even walk in the door is great. 45 minutes, let's go home. But the other ones we have to battle it out, you might be there for 2 or 3 hours.
But in asylum cases in particular, they're emotional, they're upset, and you say, we're going to reserve appeal. I'm not filing an appeal, I'm reserving the appeal. I'm giving you the 30 days to calm down, think about it,